What is up, folks? Addy Ads here. It's Wednesday. It's the 12th January. Happy New Year 2022. Judge Lewis Kaplan has denied Prince Andrew's somewhat royal motion to dismiss the civil suit against him brought by Virginia Roberts Giuffre, which is something that I actually predicted just based on that hearing that I tuned into the other week. I guess that was last week, wasn't it? On Tuesday. So that is good news, I think, for anyone who is on the side of truth, I think, in this case. I'm going to be covering a bit more about Jurorgate later on, but I wanted to focus principally on this motion and additionally, this other document that was filed today, which is a lot shorter. So I'm going to cover that one first. This is United States District Court, Southern District of New York, United States of America versus Ghislaine Maxwell, defendant. Allison J. Nathan, District Judge. Counsel for juror number 50 has submitted a motion to intervene and to be provided a copy of the jurors' completed questionnaire and voir dire. The motion has been submitted via email to allow the parties the opportunity to propose and the court to consider any necessary redactions. The parties are ordered to submit via email any proposed redactions on or before tomorrow, January 13th, 2022, justifying any such request by reference to the three-part test articulated by the Second Circuit and Lugosh vs. Pyramid Company of Onondaga. If any redactions are proposed, the court will determine whether any are appropriate and then docket the motion. The party shall respond to Juror 50's motion on or before the 20th of January 2022 upon further reflection, unless and until juror number 50, Scotty David, is permitted to intervene. He may have no standing to be heard on the question of whether an inquiry should be conducted. Accordingly, the court withdraws the aspect of its prior order setting January 26, 2022 as the date by which counsel for juror 50 should file a submission on the issue of the appropriateness of an inquiry, docket number 571. The court will hear from the parties first regarding juror 50, Scotty David's pending motion. Depending on the resolution of that motion, the court will provide further guidance to counsel for juror 50 regarding any permitted submission. If a further submission is permitted, the court will provide ECF docketing access to counsel for juror 50, Scotty David, at that time. So ordered, January the 12th, today, 2022, Allison J. Nathan, United States District Judge. So we're going to see if my guess would be there's going to be a handful of redactions on that. If there are, I'm guessing that's my guess. I hope I'm wrong. I hope this is minimally redacted questionnaire. I think it'd be really interesting to know what they asked the jurors, and moreover, show a bit of transparency, albeit this late in the game. Now, that being said, I do want to go over this document that was released regarding the motion to dismiss by Judge Lewis Kaplan. Again, this is a separate case from the Ghislaine Maxwell trial. This is a different judge as well. So I wanted to make that clear. But nonetheless, this is all under the umbrella of the Epstein Maxwell network. And that being said, let us move forward. Andrew's attorneys argued in their motion to dismiss the suit that Giuffre was barred from suing him because of a 2009 settlement agreement she inked with Epstein to dismiss a Florida suit she brought against the pedophile. And let me just bring this up in case people want to. Well, I know it's always a better experience with the graphics, so I'm going to bring up this of Mr. Andrew, the Queen's favorite son, speculated to be by some as the highest ranking intelligence officer for the Queen. The agreement releases other potential defendants, quote, from being sued by Giuffre, but Kaplan wrote in his decision that the language is too ambiguous in the agreement for him to dismiss the suit against Andrew. Quote, the parties have articulated at least two reasonable interpretations of the critical language. The agreement, therefore, is ambiguous. Accordingly, the determination of the meaning of the release language in the 2009 agreement must await further proceedings, Kaplan wrote in the opinion. Okay, so let's do this, folks. Let us do this. Let me find it here, and I hope everybody enjoyed the thumbnail on that. And which one is this? Okay, here we are. So, Virginia L. Giuffre, the plaintiff in the United States District Court, Southern District of New York, against Prince Andrew, Duke of York, in his personal capacity, also known as Andrew Albert Christian Edward, defendant. Appearances: David Boys, Sigrid Macaulay, Andrew Villacastin, Erica Nyborg Birch, Sabina Mariella, Boys, Schiller, Flexner, attorneys for the plaintiff. For the defense, Andrew Bretler, Melissa Lerner, Labley, and Singer PC, attorneys for defendant. Okay, let's get into this, folks. Let's get into so we know the players now. Obviously, Lewis A. Kaplan, district judge. Plaintiff Virginia Roberts Giuffre brings this action against defendant Prince Andrew, Duke of York, for battery and intentional infliction of emotional distress. In short, she alleges that the late Jeffrey Epstein and others trafficked her to Prince Andrew, who took advantage of the situation by sexually abusing her when she was under the age of 18. Defendant denies Ms. Giuffre's allegations and attacks her credibility and motives. He asserts that she was complicit in Epstein's unlawful activities, but this is a motion to dismiss Ms. Giuffre's complaint as legally insufficient, not to determine the truth or falsity of charges in her complaint. And defendant relies mainly, although not exclusively, on a 2009 agreement between Ms. Giuffre and Epstein that settled a different lawsuit between Giuffre and Epstein. That defendant now argues released him from any liability to Ms. Giuffre. The fact that defendant has brought the matter before the court on a motion to dismiss the complaint as legally insufficient is of central importance, as is well known to lawyers but perhaps not known to the lay public. The defendant, by making this motion, placed upon the court the unyielding duty to assume, for the purposes of this motion only, the truth of all of plaintiff's allegations, and to draw in plaintiff's favor all inferences that reasonably may be drawn from those allegations. In consequence, the law prohibits the court from considering at this stage of the proceedings defendant's efforts to cast doubt on the truth of Ms. Giuffre's allegations, even though his efforts would be permissible at a trial. In a similar vein, and for similar reasons, it is not open to the court now to decide as a matter of fact just what the parties to the release in the 2009 settlement agreement signed by Ms. Giuffre and Jeffrey Epstein actually meant. As will appear more fully below, the court's job at this juncture is simply to determine whether there are two or more reasonable interpretations of that document. If there are, the determination of the right or controlling interpretation must await further proceedings. Facts. Except as otherwise noted, the facts are drawn from Ms. Giuffre's complaint. It bears repeating that its allegations are deemed true for purposes of this motion, whatever a trier of fact ultimately might determine at a trial. The Epstein sex trafficking scheme. Plaintiff's allegations arise principally from a sex trafficking scheme orchestrated by the late sex offender Jeffrey Epstein, which by now has been publicized widely. According to Ms. Giuffre's complaint, Epstein sexually abused more than 30 minor girls in the United States and overseas from between about 1999 and 2007, in concert with paid employees and others, notably Ghislaine Maxwell, who recently was convicted in this district of sex trafficking in connection with the Epstein events. Epstein and others lured vulnerable young girls into a scheme of abuse for Epstein's own sexual gratification and for that of some of his powerful and wealthy friends. Epstein relied on Maxwell and others to identify and target vulnerable young girls in numerous settings, including schools, spas, trailer parks, and the street, end quote. Epstein's recruiters lured these girls into his orbit with the promise of what appeared to be legitimate masseuse positions. Once manipulated into returning to one of Epstein's residence, however, the girls were groomed for abuse by Epstein and others through displays of wealth, power, and sexual imagery. Once initial sexual abuse had occurred, Epstein and Maxwell further manipulated the victims with a combination of promises, threats, and surveillance. At its height, Epstein's sexual abuse scheme, managed principally by Maxwell, was transcontinental. Using his private jet, Epstein trafficked dozens of minors for sexual abuse at his New York City mansion, his New Mexico ranch, his private island in the U.S. Virgin Islands, his Palm Beach, Florida estate, and elsewhere. In 2008, he pleaded guilty in Florida to procuring a minor for prostitution. Defendant's relationship with Epstein and Maxwell. Again, according to Ms. Giuffre's complaint, the defendant first met Epstein in 1999 through the former's close friend, Ghislaine Maxwell. Over the next several years, the defendant traveled with Epstein and Maxwell on Epstein's private plane and was a guest at Epstein's numerous homes, including the private island in the U.S. Virgin Islands, Little St. James, and properties in Palm Beach and New York City. Epstein and Maxwell were guests at the defendant's 40th birthday party in 2000, as well as at a birthday party that the defendant threw for Maxwell in Sandringham, United Kingdom, in the same year. In 2006, 1 month after Florida state prosecutors charged Epstein with procuring a minor for prostitution, the defendant invited Epstein to the 18th birthday party of one of the defendant's daughters. As recently as 2010, and therefore after Epstein had done jail time in connection with the 2006 Florida charges and registered as a sex offender, the defendant was photographed with Epstein and stayed at Epstein's New York City mansion. Epstein recruits plaintiff. Ms. Giuffre's complaint continues. Maxwell recruited Ms. Giuffre into Epstein's sex trafficking activities in 2000, when Ms. Giuffre was 16 years old, employed at the Mar-a-Lago Club in Palm Beach. Like other minor girls whom Epstein and Maxwell targeted, plaintiff initially was recruited to provide massages and thereafter to engage in a variety of sexual acts for Epstein. From 2000 through 2002, plaintiff traveled frequently with Epstein, both within the United States and internationally, on his private plane. In addition to being on call for Epstein for sexual purposes, plaintiff, on other occasions, was lent out to other powerful men, end quote, including the defendant. Defendant's alleged sexual abuse. The complaint alleges, and the court, for present purposes, is obliged to accept that the defendant sexually abused Ms. Giuffre when she was under the age of 18 years old. On one occasion, defendant allegedly forced plaintiff to have sex with him against her will at Maxwell's home in London. Ms. Giuffre's complaint includes a reproduction of a now widely published photograph of Ms. Giuffre, Prince Andrew, and Maxwell at Maxwell's home, which plaintiff says was taken prior to that event. On another occasion, defendant allegedly abused Ms. Giuffre during a visit to Epstein's private island, Little St. James. Ms. Giuffre alleges also that defendant abused her at Epstein's mansion on the Upper East Side of Manhattan, which lies within this judicial district. During that particular encounter, Maxwell forced, quote, plaintiff, a child, and another victim to sit on Prince Andrew's lap as Prince Andrew touched her, end quote. During this visit to New York, according to the complaint, the defendant forced Ms. Giuffre to engage in sex acts against her will and was aware both of her age and that she was a coerced sex trafficking victim. In each of these encounters, plaintiff alleges Epstein, Maxwell, and the defendant compelled her to engage in sexual acts by express or implied threat. In consequence, plaintiff feared death or physical injury to herself or another, among other repercussions, if she disobeyed. Ms. Giuffre asserts that the defendant's actions caused and continue to cause her significant emotional and psychological distress and harm. The Florida state prosecution and the federal non-prosecution agreement. At this point, it is helpful and appropriate to refer to facts not alleged in the complaint in this case, but of which the court takes judicial notice. In July 2006, a Florida state grand jury indicted Epstein in a state court on a single count of felony solicitation of prostitution, the Florida state indictment. As will appear, that charge remained pending until mid-2008. As previously noted, defendant's motion in this case relies heavily on the 2009 agreement between Epstein and Ms. Giuffre, which already is before the court as a matter of judicial notice. The 2009 agreement contains the following paragraph. The court takes judicial notice only to the extent of the facts set forth in this section of this opinion, and in case of documents, for the existence or contents of these documents, but not for the truth of assertions the documents contain. Thus, here we go. First and second parties further stipulate and agree this settlement agreement is pursuant and is in fulfillment of Jeffrey Epstein's obligations to Virginia Roberts Giuffre, pursuant to and in conformity with the non-prosecution agreement, its addendum and its affirmation between Jeffrey Epstein and the United States Attorney for the Southern District of Florida. Thus, the terms of the NPA may shed light on the meaning of the 2009 agreement. The court, therefore, takes judicial notice of the NPA, its addendum, and affirmation. For present purposes, the following terms of the NPA are of possible interest here. Epstein agreed to plead guilty to the Florida state indictment and to a state information charging him with solicitation of minors to engage in prostitution. The U.S. Attorney's Office agreed to provide Epstein's attorneys with a list of individuals whom it had identified as victims, as defined in 18 U.S.C., and in consultation with and subject to the good faith approval of Epstein's counsel, would select an attorney representative for these persons who would be paid for by Epstein. Epstein's lawyers could contact the identified individuals through that representative. Epstein agreed that if one or more of the individuals whom the government had identified as victims elected to sue Epstein, Epstein would not contest jurisdiction over him in the Florida federal court, and he would waive his right to contest his liability. In addition, he would waive his right to contest damages up to an amount as agreed to between the identified individual and Epstein, so long as the identified individual elected to proceed exclusively to waive any other claim for damages, whether pursuant to state, federal, or common law. Epstein's waivers, however, would not apply to anyone who had not been identified by the government as a victim, or having been so identified, did not proceed exclusively under 18 U.S.C. 2255. The U.S. Attorney's Office agreed that it would not prosecute Epstein nor institute any criminal charges against any potential co-conspirators of Epstein, including but not limited to 4 specifically identified persons if Epstein pleaded guilty to the Florida charges and otherwise discharged his obligations under the NPA. The NPA bears signatures dated variously in late September and October 2007. Ms. Giuffre's complaint alleges that Epstein pled guilty to the Florida information and presumably the indictment in 2008. Ms. Giuffre's Florida suit against Epstein. In May 2009, while Epstein was incarcerated in Palm Beach County, Florida, as a result of his guilty plea to the Florida state charges, Ms. Giuffre sued Epstein in the United States District Court in the Southern District of Florida as an alleged victim of Epstein's alleged federal sex trafficking, sexual exploitation, and child pornography offenses. Her complaint asserted that Epstein and Epstein's, quote, adult male peers, including royalty, politicians, academicians, businessmen, and or other professional and personal acquaintances, end quote, had sexually exploited her. Ms. Giuffre and Epstein entered into the 2009 agreement entitled Settlement Agreement and General Release, pursuant to which Giuffre voluntarily dismissed her action against Epstein in exchange for $500,000. The defendant argues that Ms. Giuffre's claims against him are barred by the terms of the 2009 agreement. The federal criminal case against Epstein. On July 2nd, 2019, a grand jury in this district indicted Epstein for an alleged sex trafficking conspiracy and the substantive crime of sex trafficking. He was arrested on July 8th, 2019. On August 10th, 2019, Epstein was found dead in a cell at the Metropolitan Correctional Center. The 2009 agreement is the crux of defendant's motion. It contains 6 and a fraction pages of substantive text consisting of 9 individually labeled provisions. These are an agreement to dismiss the Florida case, a 1.5-page provision captioned general release that contains additional covenants beyond the releasing language, a payment section, a confidentiality provision, covenants dealing with maintaining Ms. Dufresne's anonymity, a no contact covenant, a provision relating to governing law and enforcement of the agreement, a clause concerning attorney's fees, and a collection of miscellaneous provisions. A number of those provisions bear importantly on the resolution of this motion and are discussed in detail below, so there is no need to quote or summarize them in great detail here. Suffice it to say, by way of introduction, that this motion raises 2 pivotal issues regarding the 2009 agreement. Whether the 2009 agreement demonstrates that its releasing language in Section 2 unambiguously applies to this defendant, and if so, whether the defendant, who is not a party to nor mentioned in the agreement, is entitled to invoke it. The 2009 agreement is far from a model of clear and precise drafting. Both sides agree that Epstein and Ms. Dufresne agreed to its language. It must have meant something to them. But Ms. Dufresne and the defendant in this case disagree emphatically as to what it meant with respect to both issues. The defendant moves to dismiss pursuant to Rule 12b-6. As noted previously, the court in this posture must accept as true all well-pleaded factual allegations in the complaint and draw all reasonable inferences that can be drawn from them in the light most favorable to the plaintiff. With limited exceptions, the motion must be decided solely on the basis of the allegations of the complaint, without regard to any extraneous claims or materials. The 2009 agreement neither appears in nor is referred to in the complaint, but the copy before the court concededly is authentic. Its wording is undisputed, and the court consequently has taken judicial notice of it. Moreover, notwithstanding the general rule that an affirmative defense is not considered at this stage of the litigation, such a defense may be raised by a pre-answer motion to dismiss if the defense appears on the face of the complaint. And while the defendant's argument does not rest on the face of the complaint, here that is a distinction without a difference in light of the fact that the wording of the 2009 agreement is accepted by both parties. Accordingly, the court considers defendant's argument. And it continues analyzing the 2009 agreement. I just want to skip ahead to the conclusion here because I think it goes for 46 pages. So that's a good hour dictation, I would say. So let's go here. For the foregoing reasons, defendant's motion to dismiss the complaint or for a more definite statement is denied in all respects. Given the court's limited task of ruling on this motion, nothing in this opinion or previously in these proceedings properly may be construed as indicating a view with respect to the truth of the charges or countercharges or as to the intention of the parties in entering the 2009 agreement. So ordered, Louis A. Kaplan, United States District Judge, January the 11th, 2022. So that was yesterday. That broke. Let me just check out comments here. Thanks for tuning in, folks. And let me just see where we're at here. Okay. So I want to discuss this story by Adam Klasfeld, who is one of the court reporters at the SDNY. I had a brief interaction with him requesting an interview. He politely declined. Quote, obviously, this is a big deal. I'm going to bring this up right now. Give me a second here. And also, Sean Atwood Roundtable for people who attended the trial later today, 3 p.m. Eastern Standard Time on Sean's Patreon will be reposted at a later time on his Odyssey. as far as I know. And here it is. Obviously, this is a big deal. End quote. Reporter who broke Ghislaine Maxwell juror story opens up about the complicated fallout. Adam Klasfeld. When she landed the world's first interview with the Ghislaine Maxwell juror, journalist and author Lucia Osborne Crowley knew that the story would be significant and perhaps even fraught. It was a really, really overwhelming interview for me because there were so many things going through my head. Osborne Crowley recounted in a recent podcast. The juror, once anonymized only as juror number 50, now known as Scott David, has told her that he was a survivor of childhood sexual abuse. He also told her that those experiences informed his decision to convict Maxwell of sex trafficking and other federal crimes that could lock up the Jeffrey Epstein accomplice for the rest of her life. This is a verdict for all the victims, David declared in what ran as a pull quote in the headline of Osborne Crowley's exclusive in the UK's Independent. Now that verdict may stand in turmoil. She's a trained lawyer working for the legal publication Law 360. Osborne Crowley surmised that the story could have had a fallout. Oh, really? That was quite a surmisal. I don't think suppressing a story like this would have been the right thing to do as a journalist, but I also worked in law, and obviously there was a part of me that felt really worried about the impact this could have in the court. I tend to side with truth, so I don't really, I don't think I falter for that at all. I would have probably broke it. Shoot. Why didn't I? I'm jealous. Sensing that obviously this is a big deal, she noted the story was sent for legal review. As she first encountered the information as a lawyer, she noted legal ethics would compel her to disclose it. Beyond her professional reactions as a journalist, author, and attorney, Osborne Crowley had another facet of her identity compounding her ambivalence, her experiences as a survivor of childhood sexual abuse. Her outspokenness about her experience being raped at the age of 15 years old when she was on track to be an Olympic gymnast informed her two published books, I Choose Elena and My Body Keeps Your Secrets. As a longtime reporter on the topic of sexual violence, Osborne Crowley said, I got a lot of hate on the internet. But this is different, of course, because a lot of criticism is coming from people who are advocating for victims. And that is really difficult for me because I would have never intended that outcome. It is far from clear that Scotty David's disclosure ultimately will spark a new trial for Maxwell, or that if it does, the initial interview would be the precipitating factor. The same jurors subsequently spoke to the UK Daily Mail and Reuters. The New York Times later reported that a second juror described being a sexual abuse survivor, and the Mail on Sunday reported that there may be a third. I want to see the videos as we do with Scotty David. As of press time, only David's disclosure has led to any reaction by Maxwell's prosecutors and defense attorneys. Those have revolved around David's alleged omissions and misstatements on his jury questionnaire rather than his status as a survivor. Though what the other jurors wrote in their questionnaires remains unknown, the silence of Maxwell's lawyers on that subject could suggest that the other jurors did disclose their histories of sexual abuse and were impaneled anyway. Quote, I think that's important, that the lesson we take away isn't that it's right to think that sexual abuse survivors shouldn't be on these kinds of juries, because that's not the law. And also, if it were the law, I think that would be a really big problem, Osborne Crowley noted. The jury questionnaire used in the Maxwell case contained the extremely broad question, have you or a friend or family member ever been the victim of sexual harassment, sexual abuse, or sexual assault? Rattling off statistics, Osborne Crowley noted that excluding everyone who checked off a yes answer to that query from jury service would be unrealistic. Based on the latest statistics I've been able to find, 81% of women say they've been sexually harassed, adding that the number is 43% for men. Once one accounts for those whose friends or family members fit in those categories, that's a huge chunk of the population. Born in Australia and now living in London, Osborne Crowley notes that both countries forbid reporters from interviewing jurors, but she understands the ideals of the U.S. system. The whole quote, the whole point of allowing jurors to speak to journalists is that we want to know how this process works. We want transparency. We need transparency, and there's something to be addressed. We want to be able to address it, end quote. On Monday evening, Maxwell's prosecutors wanted U.S. District Judge Allison Nathan to schedule sentencing within 3 to 4 months. Defense attorneys want the judge to resolve their motion for a new trial before setting any proceedings. And this was yesterday at 1:57 p.m. So just wanted to say that. I know people are pretty conflicted on whether or not Maxwell is going to get a new trial. I know I don't know if it's defeatism, pessimism. I think it's skepticism, probably a healthy skepticism people have about this whole case, which is completely understandable. I can't say I have a crystal ball. And in that sense, it helps me because then I can be like, sorry, guys, I'm just reporting what's happening. So that being said, I think I would want him to stick. I don't think we want a new trial. I really don't think that's in the people's best interest. Already, it looks like she's going to get her perjury charges dismissed. So it's unfortunate. Juror Scotty David again gave interviews, and I noticed that all his social media accounts were taken down. I believe I was the first person to point that out. On the evening of the 10th of this week, so that was Monday, United States submitted a joint letter. The government believes that the court should order preparation of the pre-sentence investigation report and schedule a sentencing proceeding approximately 3 to 4 months from today's date. I believe I covered that already, but just revisiting that schedule permits sufficient time for the preparation of the PSR, pre-sentence investigation report, and resolution of post-trial motions. In the event the defendant's post-trial motions are denied, the government is prepared to dismiss the severed perjury counts at the time of sentencing. And I wanted to touch on this as well. Attorney Todd Spodek, who was originally assigned to be the defense for Scotty David, actually sent an email to Matthew Lee. By the way, Matthew Russell Lee, Inner City Press, is going to be joining us today on Sean Atwood's show, among other people. So just wanted to throw that in there. Without comment on who it is. Oh, wait. Okay, here we go. Okay, so yeah, it is to Inner City Press. Subject, Danforth with guideline of 57 months. As Maxwell's jury, temporary CGA gets 34 months. From Todd Spodek to Inner City Press. FYI, Juror 50 was appointed CGA and in lieu of CGA hired my firm. Thanks, Todd Spodek. Spodek Law Group, duly noted and responded to. There's this. But previously, the same Scotty. The U.S. on January 5th wrote in, Dear Judge Nathan, the government has become aware that a juror has given several interviews to press outlets regarding his jury service in this case. And as noted during the trial by Inner City Press, for example, with regard to Team Maxwell's Leah Safian having and sharing her smartphone in the courtroom, there is something very wrong and untransparent about this trial. Interesting note about that. John Kiriakou said she had that privilege because of something called pro hoc vice, I believe it is. I didn't know that applied in the situation that explained it, but I want to ask Matthew Lee about that in the chat today. It was the secrecy, starting with denial of the public call-in line and continuing through juror selection with press ban from significant parts that allowed it. Now what? Scotty David fled his apartment in Manhattan with a box of family-size Cheez-Its, as we saw. Cheez-Its. Why Cheez-Its? I don't know. So is this Cheez-It thing deeper? Is this a deeper Cheez-It clue, or is it a red herring? Cheez-It's a red herring. We don't know. We're going to find out. I wanted to share this tweet from Maria Farmer. I'm going to bring it up, actually, because I haven't been doing that when I've been sharing Maria Farmer's tweets. She's at Artistic Blower on Twitter. She tweets Jim Comey, why aren't you or Preet Bharara, he's former United States Attorney, Southern District of New York, terribly embarrassed about not prosecuting Epstein and Maxwell for decades? SDNY News thinks we aren't watching as your daughter #deputy dog acts as prosecutor. You are a pedo enabler who harms the innocent. That is your legacy. And that just got a retweet from me. So go and give Maria Farmer a follow if you can. She follows me, and we retweet each other pretty regularly. So just going over Preet Bharara here really quick. He is a lawyer, author, and now podcaster, former federal prosecutor, served as the United States Attorney for the Southern District of New York from 2009 to 2017. Very brief introduction there of Preet Bharara, but that's what I wanted to share there. Why not Cheez-Its? Asks Greg Clark. Why not Cheez-Its? That's a good question. She needs to go down. She's disgusting, says Macker. 7. BBC is reporting now that Prince Andrew to face we covered that. The whole thing just makes my stomach turn. Those poor kids. Thanks for your coverage, Addy. Everyone would like a list of all who spent time at Epstein Island. Prince Andrew, vomit emoji. You are really on this, Addy. Thanks, says I see you. Thanks for checking in, Dolly, Francine, Romy. I like that name. It's a cool name. And I said I see you. So why not Cheez-Its? It's a great question by Greg Clark. Okay. More to cover here, folks. Andrew also said that Giuffre is seeking, quote, another payday at his expense, and testimony from a new witness who says she does not think that Ms. Giuffre deserves any compensation, end quote, is said by experts to potentially provide a powerful evidence in this case. So that's first time I've heard about that. Possible new female witness testifying in favor of Mr. Andrew. So who is that? What's the motivation there? What's the drive? Why would you want to do that? It's because it's a prince. But in America, people are like, who cares? Prince? Nobody cares about that. But who was the source? How did Lucia Crowley get in touch with this guy? Did somebody, I heard a rumor that somebody messaged his Instagram to her. Don't know if that's true or not. But Maxwell's lawyers, per the Daily Mail, claimed to have found a third juror in her sex trafficking trial who lied about being abused, as the socialite is given hope of a retrial, a ray of light from Ms. Maxwell, perhaps. A second unidentified juror also told the New York Times much the same, that they had been abused as well. The socialite given new hope, but a source said Maxwell's legal team feel, quote, confident a third juror lied on their jury application. There are also questions over a fourth juror, so this thing is up in the air. Are they BSing or not? I think that's a great question. And let me bring this up because there's a picture of Caroline. Andriano finally zoomed in there so we can kind of see what she looks like. She recently stepped forward out of the pseudonymous state of being. Going from Caroline to Caroline Andriano. I can't remember the outlet that she first gave an interview to, but she gave evidence at the trial, of course, and it looks like it was with the Daily Mail, asserting that Virginia Roberts had told her she slept with Prince Andrew in London and had shown her the infamous photo of her with the prince. So this fourth juror, or third juror, comes in light of that, or shortly after, shall we say. And again, Scotty David has hired a lawyer. Lawyers from Maxwell demanding an immediate retrial. Quote, they said they had discussed the experience during deliberations and that the revelation had appeared to help shape the jury's discussions. So really not, people don't seem to be taking the second and third jurors coming forward as seriously. I haven't seen any pictures. Don't know if that's hearsay, fake news, mainstream media BS, perhaps on behalf of Ghislaine Maxwell. I don't think that possibility can be ruled out because it's something we've seen happen before and to an extent are still seeing happen today. But I wanted to ask once more about these entries. Well, I guess not once more because I haven't asked already. On court listener in the docket for the United States versus Maxwell, 120 CR 00330 on, and let me, hold on. See, now it's, where'd you get away? She got away from me. Okay, so let me go to the most recent here. Yes, so it said jury trial on the 10th and the 11th, I believe it was. And I didn't understand that. I had somebody ask me about it. I don't know what it means, guys. I'm not a lawyer, but I'm learning about this sort of stuff. It's been fun covering it. Here's the right page, I believe. Let me see. Okay, we are in January now. And let me scroll down. January 12th. Here we go. 11th, jury trial. 10th, jury trial. Oh, here, let me pull it up there. Sorry, guys. There it is. This is on court listener on the docket. What does that mean? I covered this, but reiterating, parties ordered to submit redactions via email on or before January 13th, 2022. So, I don't know. Maybe somebody can let me know what's going on there with the jury trial. But just wanted to update people on the rejection by Lewis Kaplan of Prince Andrew's royal motion to dismiss the suit. This will be available on Rockfin for video, and for audio, it should be available anywhere podcasts are listened to: Spreaker, iTunes, Spotify, etc. If people want to help out with the podcast, because they are monetized, so that's great. But again, I'm still giving away pretty much everything for free. If you want to buy me a coffee or a tea, that is in the description box below, or at buymeacoffee.com/AddieAds, patreon.com/AddieAds, Venmo, Cash App. I believe those are both AddieAds, but they're in the show notes. But Brockfin is where I'm sending people now, so do check that out if you will. I'm going to be on the move again, more than likely, pretty soon here, because that's what I do. And I will let people know when and where once I know when and where. Stay frosty, and we'll see everybody next time. Join us on Atwood if you can. It's on his Patreon. Again, replay will be posted. Should be a great roundtable. Cheers.